Hello everybody, my name's Tony Vellini. Thank you in advance for listening. This is LARC 2, Week 3. Some topics today. We're going to do a brief memo refresher and then talk about report to supervising attorney. We'll do a Blue Book review and then we'll talk about updating research. And this is basically the function of shepherdizing or key citing cases, checking the later history. So, let's first look at the schedule for the next few weeks. And so we're in week 3. Here's our topics, and I'll be assigning assignments 3, 4, and 5. I'm going to put those on D2L, but if you have a different LARC professor, you'll want to look out for instructions either on D2L or by email, providing those specific assignments. Hopefully you turned in your direct response memo and you did your Blue Book exercises, because we'll be checking those soon. Okay, so I've got some red arrows here. So next week, reports to supervisor. So there's no class. I will be emailing out a Google Doc to all of my students, but see what your LARC professor does. Of course, Blue Book Quiz 1 next week, you'll want to do that. Week 5, I'd like you to bring your laptop. There's a research exercise that I don't think we're going to do this week on account of the class cancellation, so I'd like to do that in week 5. Predictive memo, so I assigned predictive memo today, and it's due in 3 weeks, and that's what we'll be talking about in this report to supervisor. Let's look down at week 6 here. This is where we shift to persuasive writing, writing to a court. And some students really enjoy that shift, so hopefully you're one of those students. Week 7, also bring your laptop, because we'll be doing an in-class research exercise. So as I mentioned, assignments 3, 4, and 5, I'm going to be putting these on D2L, but be on the lookout for D2L or email instructions from your professor. So part 1, memo refresher. Let's consider all the memo parts and then consider goals for each of those parts, because obviously students can forget details over the winter break when you're hopefully in the islands having fun and not thinking about legal analysis. So 6 memo components. Heading, questions presented, also known as issues, if you're into the whole brevity thing. Brief answers. 4, statement of facts. 5, discussion. And the discussion, that's where you describe the law and then apply the law. And then your final conclusion, which is hopefully pretty brief. So we'll talk about each of these parts, except for the heading. I think the heading, you can just look at a sample. It's pretty straightforward. To, from, subject, date. So I'm not going to talk about the heading. But the questions presented and issues, oftentimes you have one major question presented for each major issue, also known as an umbrella issue, like, Roman numeral 1. And you could have sub-issues like A, B, C, and so forth. And, with your issue structure, you want to, your issues on page 1, you should have the same order of issues in your later discussion, and you should use issue headings in your discussion that are consistent with your issues. That's really important. Next bullet, some attorneys prefer that you use descriptive terms rather than using names. And so see what your LARC professor prefers. And I have an asterisk here. We'll see. I have a quirk. I tend to like using client names. That's just me. Well, it's me and some other attorneys as well. The formula for issues, we're going to look at this in more detail, but it's basically the legal question plus the ODFs. Finally, you want a single space within each issue, but you want to put a line space between each issue. We'll see an example of that. And hey, if your biggest problem is not having a line space, I think you're okay. But try to remember this with regard to spacing. So here's my quirk with issues. I like to use a client name and opposition name, but again, your LARC professor might not want this style, so follow your professor's preference. So my example, whether Sally Smith appears liable. I just use her name. That's just my style, or lack of style, perhaps. Additional issue drafting ideas. So sometimes you have an umbrella issue with some sub-issues, and sometimes you don't. So every memo can have a different structure depending on the rules for the particular issues, and oftentimes your job is to figure out a logical issue structure based on those rules. And so example 1, I could have separate issues. So breach of duty, number 1. Number 2, breach of good faith. Maybe these are separate questions. But example 2, if I have something like false imprisonment or negligence where there's elements, oftentimes the sub-issue structure is the way to go for that type of issue. Now, with issue drafting, one of the things you want to do, and students were improving on this with the final memo in the fall, identify some important facts in the issues and then explain why they matter in the brief answers. And so here's a question. Why should I include facts in the issues? And I've got 2 answers. Answer number 1, because I said so. Answer number 1, because the grading rubric requires them. Okay, well, I think a better answer is answer 2, raising facts in the issues and then explaining why they matter in the brief answers. It makes the first page or 2 of your memo a more helpful executive summary of the legal analysis. And I'm going to talk about this more in a couple of slides, but that's the main idea here. So let's take a look at an issue. So I copied this sample issue from another law school, labeled some parts. So right here I've got jurisdictional Q. That can be very helpful. Point out the jurisdiction. And then this other law school has the same quirk as me. They're using a party name. Fine. And then there's the legal question. And basically the first part of this issue, you know, New York law, was there an offer? You know, that's the legal question. Was there a binding offer? And then there's a connecting word, when. All right, so after the legal question, you'll have a connecting word oftentimes. And then after that connecting word, you have the key facts. So here there's key facts of, you know, manufacturer closeout, early shoppers would be rewarded, and so forth. And so this should be familiar, hopefully. And again, let's apply this formula. Legal question plus connecting word plus key facts. So whether there's an offer, considering, there's my connecting word, and then key facts, the closeout, and the reward, and all that good stuff. And so here's a side note. Early on in your memo writing process, you might simply outline your issues. And maybe toward the end of your memo writing process is where you really fine-tune your issues and brief answers, when you really have a good handle on your arguments. And so maybe my first draft of memo, I could have just offer, question mark, insert some key facts, and maybe that's how I get started while I work on other parts of the memo. So let's consider another issue sample. So I've got a screenshot below of a student memo from a few years ago. And so here's some ideas. The below issues, they don't identify any facts, and so there's some point loss there. Also, I need line spaces between 1 and A and B. So those blue arrows, that's where you should have a line space. And the legal questions were not so clear, you know, so there's room for improvement here. Motion for contributory infringement, I've never heard of such a motion. You know, I've heard of motion to dismiss, motion for summary judgment. So probably want to fine-tune that language, you know. So sometimes just expressing the legal questions clearly is a challenge. And, you know, let's just pause for a second and think about your audience for the issues and brief answers. So let's say one partner at your firm just wants to review pages 1 to 2 of your memo for a quick heads up of what's going on. And so the questions, here's what your audience wants to know. What are the specific legal questions? Second, what are the key facts that really matter? Third, brief answers. What are the best arguments for how or why those facts support the legal conclusions? And so my next bullet, trying to communicate all of these aspects clearly and succinctly, it's a big challenge. So writing really good issues and brief answers, it's a black belt skill that you're working toward, and Hopefully you're getting close to that black belt level. Now, as I said earlier, oftentimes issues and brief answers are part of your final editing once you've really nailed down your arguments. So let's improve the prior example. Let me go back for a second. So I had this example. Let's improve it. So here's what I could do. I could use this formula, whether, legal question, connecting word, and then fact. So legal question, whether complaint sufficiently alleges infringement to survive motion to dismiss, considering, there's my connecting word. Then here's a fact, complaint makes no reference to any direct infringer. So for simplicity, I'm just writing one issue just to illustrate what's going on. And so brief answer, what I want to do is I first want to directly answer the question. So the question is, will this complaint survive motion to dismiss? I'm saying no, complaint unlikely to survive motion to dismiss. So I want that very direct answer to the question. After that, I explain why the facts matter, because contributory infringement claim requires identification of a direct infringer. So another side note, I've got a few side notes here. Whether, some LARC professors dislike whether. I'm okay with it, that's just me. Again, now, when you write issues and brief answers for your memo, who knows, maybe you'll have a couple of legal questions, and maybe you'll have, I don't know, 2 or 3 facts that you're working into the issue. So this is a simplified example. I guess it depends on your assignment, right? So brief answers, you want to answer the question presented. We talked about that. Directly answer the legal question, and then provide your reasoning, explain why you're taking that position. You want to start with words like yes or no, or probably not, or other language of probability like may or might. And we'll talk about that some more in a later slide. Words of probability. The brief answer should stand on its own. So somebody should be able to read the brief answer and say, okay, it's clear what your legal conclusion is and what your reasoning is regarding certain facts. Next bullet, generally no case cites. And let's think about this. The issues and brief answers are really a summary. Okay, so all the bells and whistles like citations and everything else, all the rules and everything, that's for later in the memo. Issues and brief answers are just a summary. Now again, brief answers, just like the issues, you single space each brief answer, but make sure to put a line space between each individual brief answer. Separate them with a line space. So again, this idea, answer the question first, then provide reasoning. So the question was, will the complaint survive motion to dismiss? Direct answer, the complaint is unlikely to survive motion to dismiss. State why. So there's a good example, right? But then the not so good example, actually this really, I hate this. What if my answer said, it depends, the court will have to decide? Oh, that's terrible. And, the client hired you to provide an answer, a prediction of who might win. So if you just say, I don't know, it depends, court will have to decide, and then you send your client a really big invoice, your client's not going to be happy. I don't think you really provided much value saying, I don't know, a court's going to decide. Okay. So start with yes, no, probably, and so I would use the word, yes or no if the issue is straightforward, if I'm feeling pretty confident in the conclusion. On the other hand, I might use words like probably or court may find. This is often helpful where the issue is tough. So maybe there's competing arguments on either side, and you don't know for sure how a court will decide. You're at least offering a theory. And that's good. You want to at least offer a theory. Next part of the memo, the statement of facts. So what have we done? Headings, issues, brief answers. Now we're at statement of facts. So tell the story of the problem in a neutral way, an objective way. And there's 3 kinds of facts to think about. Legally relevant facts. So these are the facts that really matter for your arguments. There's the background facts, maybe facts like who, what, where, when you're telling the story. They're helpful background facts. Then there's the emotional facts. Maybe these are facts that seem worth bringing up, but they don't directly relate to a specific argument. Another idea is you cannot ignore bad facts, right? So if there's a fact that works against your client, it has to go in the memo. You have to analyze it. Why? It's going to come up in litigation if this matter gets litigated, and a court's going to be looking at it. So don't hide it. And remember, sometimes with a memo, it's objective advice, your objective prediction. And so you're either going to tell your client, yeah, it looks like you're going to win on this issue, or sometimes you tell your client, you know, I think you're going to lose on this issue, and, you know, here's the best arguments I have for you, but I think you're going to lose, and so we should settle this case. And that's helpful advice for the client. And so don't sweep those bad facts under the rug. You're not doing your client any favors if you're doing that. Because the worst thing is to tell your client, yeah, we're going to win. Okay, then the client's really happy. But if that's the wrong advice, and you go through some costly lawsuit, you really have not helped your client. So, statement of facts, here's some suggestions. Generally use a chronological flow. Think about including helpful who, what, where, when info when telling a story. Definitely include any fact that you later use in an argument in your memo. If you're using a fact for an argument, it's an ODF and it belongs in the statement of facts. Last bullet, if you have a really tough word limit, you probably want to strip your facts down as much as possible to those really important ODFs, the facts that really matter to your arguments. So facts generally use a chronological flow. Now you might be very creative, but just remember, your statement of facts is not a Quentin Tarantino movie. All right, you don't want to start at the end and then go back to the beginning. This is not the way to tell a story to a busy lawyer. Bad move. So no, none of this in medias res stuff. Now there is an exception. I've had some memos in the past where, you know, the fact pattern involved a contract, and some students said, okay, well, I'm going to start out saying there's a contract in place and here's what it was about, and then from there I'm going to talk about pre-contract execution facts. You know, maybe the issue was fraud in the inducement or something like that. So the students generally stuck with chronological flow, but they started with the contract. And to me that seemed okay, it seemed logical. But again, you're generally using a chronological flow with facts. That's how you tell a story. At least with legal writing. If you become the next John Grisham, then use in medias res for a novel. But facts, again, try to include some who, what, where, when info, space permitting. You know, some of this can be helpful. And remember, your memo is litigation prep because these issues might get litigated. So let's look at who. You might want to identify, you know, relevant people. Who will you sue, or who will you call as a witness for a deposition? What happened? Obviously you need this. What about the where question? So where things happen, that could be relevant to jurisdiction and venue. When things happen, that could be relevant to statute of limitations, right? So, I don't know, a copyright infringement claim, you've got a 3-year statute of limitations. If you're suing a municipality on a tort claim, there's a 1-year statute of limitations. So sometimes timing matters, and, you know, I think generally you tell a story, people want to know when things happen. So who, what, where, when, to the extent practical, based on your word limit. So facts, other ideas. Start with a topic sentence, introduce the parties, and this is in the grading rubric. So this is a dispute between Joe Smith, John Bonham, you know, who owns the copyrights to some song. Okay, great, I've introduced the parties and laid out the nature of the dispute. Another idea with facts, just the facts, man. So a common phrase in 1950s shows, detective shows, or Perry Mason type shows. So you want to stick to the facts in the facts. How about that? There's a label, there's a heading, it says facts, stick to the facts. So you don't want to have cites to legal authorities, you don't want to put rules in your facts, you don't want to put arguments in your facts, it's just the facts. Avoid characterization of facts, because characterization is more for argument. So instead of saying brutally handcuffed, I think a more neutral statement of facts would say, you know, photos showed bruising around the wrists 4 days after the arrest. That would be more objective. Now we're at the discussion portion of the memo. So where were we? We had heading, issues and brief answers, facts. Now we're at the discussion portion. And so what you want to start with the thesis paragraph, and what you're doing here is you're briefly reminding your reader of the key legal conclusions. And so a thesis paragraph, you could also call it a roadmap. And I've got an asterisk here. Brief reminder is good because you already summarized your key reasoning in the brief answer. So it's just a brief reminder of key legal conclusions. Now for each issue, you want to describe the law and then apply the law. That's a big picture idea with the discussion. Describe the law, apply the law. So here's the discussion flow. We talked about thesis paragraph or roadmap, paragraphs that explain the law, okay, and then paragraphs that apply the law, and then your final conclusion in your memo. And so this is really a CRAC structure. So you've heard of IRAC, maybe you've heard of CRAC. The thesis, here's my conclusions. And then there's the rules and maybe a case description. And then finally there's the arguments, the application, and then there's the final C, the conclusion. And so, yeah. So now organize your discussion by legal issues. So probably separate IRACs or CRACs. And so yes, so I could have issue 1, here's the law on issue 1, then I apply the law, provide a conclusion. Issue 2, I can follow the same structure. And I've got an asterisk here. I know in my memo in the fall, I just said, oh, tough word limit. Let's write a case description for only one of the issues. So you'll have to look for your professor's instructions on how many case descriptions. But anyway, the point of this slide is that separate IRACs or CRACs is a common and effective structure for your discussion of a memo. Now, your professor may offer additional tips on helpful substructures. So, you know, who knows, maybe issue A, you want to break it down into sub-issues 1 and 2 and have many thesis paragraphs and rule developments. And so, you know, the number of headings, you know, can vary. And again, this sort of thing varies with the nature of the assignment. So you could think about this sort of thing and see if your professor has any tips for you if you're going to have substructures. So in the discussion, you will need rules. Rules of law are a big deal. You got to have rules. A lawyer is no good without the rules. That's like a mechanic without any tools. So think about the types of rules. If there's a statute, put it in there. Other thoughts, you know, you're deciding, what do I need to communicate rule-wise? What's the purpose of the rule? What are the important elements of the rule if it's a criminal offense or cause of action? Are there any factors to describe? Are there any exceptions or defenses? You know, exceptions and defenses, you know, one of the things you might think about, are there rules that favor my client, and are there some other rules that favor the other side? Maybe I'll try to get both of those types of rules in there. And, you know, when you have a word limit, you have to decide which rules are most important. So you have to prioritize. And obviously, you know, you can't copy large passages of rules out of cases. You're just not going to have room for that. And so you have to be strategic with your rules. Try to include what's helpful and necessary. But you can't, you know, write War and Peace with your rules. So in the discussion, you're going to have at least one case description, right? And so what are the parts of a case description? Well, you've got your topic sentence, your ODFs, holding, and reasoning, and so this should be familiar from the fall, unless you forgot everything. And so with case descriptions, so here's my comments to my students, but this probably applies to 1Ls everywhere. Think about at least a couple of things. Generally reduce non-ODF content, and along these lines consider that arguments are not ODFs, and so we'll look at an example. Another idea is reduce excess procedure in the holding statement. You want to have a simple and effective holding statement in your case description. Okay, so in the fall, I gave my students this exercise. I gave them this long case description of Lefkowitz, and there were so many facts that we could cross out. So if we go toward the top here on the second line, April 1956, that has no relevance to whether the ad was a binding offer. So we crossed out April 1956. But what the ad said, that was highly relevant, so we left that in. The guy's name, the plaintiff's name, Morris Lefkowitz, doesn't matter to the issue, so we crossed it out. And now here's some ideas that I was getting at on the prior slide. So craft a simple holding. We could reduce the procedure. There's a lot of stuff here. Defendant, what type of motion the defendant filed, and all this, what happened with the appellate court versus trial court. You don't need all of that. A good holding statement just says, okay, court held there was a binding offer. That's your holding statement. You focus on the issue, not all this other procedural stuff. Another idea in here, I'm looking at some crossed out language. On appeal, the store asserted newspaper ads are generally unilateral offers. So arguments are not ODF. Arguments are assertions. So you can usually remove arguments from your case description. And again, when you think about a case description, what do you need? Topic sentence that tells you what the important legal conclusion is. So Lefkowitz shows binding offer. Then you need the facts. What are the facts that really matter for why there was a binding offer? Then you need a holding. Court held binding offer. Finally, you need the reasoning. What was the court's explanation for why there was a binding offer? Okay? And so once you cross out all this junk that you don't need, you end up with a fairly succinct case description. Now in your memo, maybe your case description might be a little longer. Maybe the case is more complicated. I don't know. But this is the idea here. Topic sentence, most important facts, simple holding statement if you can do that, followed by the court's helpful rationale, explanation for the holding. Okay, now in the discussion you'll have some applications where you compare client facts to precedent case facts. And you begin with a thesis sentence, which we talked about last semester. You compare outcome determinative fact from precedent case to client facts. Explain how or why compared facts support the same or different outcome. And when you're offering your comparison, try to tie in any helpful reasoning from the case. So sometimes the case has, the precedent case has no reasoning in it. It's just a conclusion. And you have to generate entirely your own explanation for how or why the compared facts support the same result. But other times it's a blend, your ideas plus court's reasoning. But one thing to think about, the thing I want to impress upon you is, if a court gives you helpful reasoning that you can use, go ahead and use it. That helps boost your score if you can find good reasoning and use it. Powerful stuff. Stare decisis, right? Orientation week. Analogy, distinction, flow. Okay, so here's the flow of the arguments, at least generally. So thesis sentence, the facts are analogous to the restraint in Smith. Okay, then you have some sort of fact comparison. So here, I made this up. There in Smith, defendant held a sword while blocking the doorway. Sounds like false imprisonment. Here, Mr. Hogan flexed his muscles while singing Don't Mess With Me. All right. So thesis sentence, compare the facts, then the reasoning. Both cases, defendant created a fear that he might use physical force and so forth, had the effect of restricting locomotion, causing him to remain when he did not wish to do so. So the reasoning part, I'm explaining how or why the factual similarity or difference supports the particular legal conclusion. And again, when you're providing this reasoning, if you're able to use the court's reasoning and cite to it, go for it if that's an option. Now again, for my students and probably 1Ls everywhere across the country, keep working on injecting specific fact comparisons to drive up your application score. So sometimes you have an easy argument where you just reference a rule and you're done. But other arguments really benefit from a good case comparison. And so In the fall memo for my students, you could compare how in Emerson, defendant concealed its true intentions and described how there's this secret intention, and then here, Easy Office, that was in the client facts, had a similar intention of taking our client off the market to boost sales of its own stuff. So then I've got reasoning after the fact comparison. Both cases, licensee misled the IP owner about large expected royalties but had no intention of actually making sales. Therefore, a court should find bad faith in both cases. And so, yeah, again, what I'm trying to do is, with the reasoning, here's the fact comparison. I describe a similarity, but then I describe why that similarity supports the legal conclusion. So, here's a silly example. If I said, in the precedent case, defendant wore a yellow shirt. Here, our client was wearing a yellow shirt, and then I'm done. That's not enough. I have to explain, why does wearing a yellow shirt in both cases support, false imprisonment or whatever the issue is? So think about that. The legal significance of your comparison, that's something you're trying to explain. Okay, so the conclusion is the final component of your memo. It's a separate component. It gets a heading. And to me, the final conclusion is the least exciting part of the memo because you've already discussed everything. And you just want to provide an overall conclusion on the umbrella issue. And you want to be very brief because you've already talked about everything. Now, sometimes you'll give some advice going forward. Here's my conclusion on Roman numeral 1 issue. And here's something else that we should look into. So sometimes you do that, advice going forward. Nothing new, right? You don't want to start adding new ideas into the conclusion. It's a conclusion. Okay, so think about that. Talk about a court. A court will likely hold, there is false imprisonment liability. Good, I'm done. Maybe that's all I need. Okay. So, thank you for listening, and I'll see you in another video.